Good afternoon, Your Honor. Daniel Magoo.
All right. Mr. Gu, you are representing yourself. I do have to apprise you that you are before the court on charge of resisting and obstructing a police officer. That is a high court misdemeanor, or what technically is known as a high court misdemeanor, and or felony punishable by up to 2 years, $2,000 fine plus court costs. There are great perils in representing yourself. In this, you have to understand that I am going to treat you the same as though you know the laws and the rules of evidence. I will not treat you worse because you are not represented. I will not treat you better or grant any favors or try to clarify anything for you. If for whatever reason during any point in this proceeding you wish to be represented by counsel and cannot afford to hire counsel, counsel will be appointed to represent you. As I have in the past hearings asked you to acknowledge what I've said, I'm going to only indicate that I believe that you understand English. You believe that the words that I have said to you are understood, so that we don't get into, you need to remove the gum from your mouth.
Mr. Emio is back, and yep, he's heading straight into chaos once again. But this time, he's about to learn the hard way why having a lawyer isn't optional, it's crucial. If you're new here, welcome. This is part 2 of a case we've covered before, so be sure to check out the first video if you haven't already. Now, let's talk Emio. Since day one, he's been making things worse for himself. Instead of respecting Judge Simpson and answering questions clearly, he's been smug, dismissive, and way too confident for someone facing serious charges. And get this, he walks into court without an attorney, chews gum in front of the judge, and acts like the rules don't apply to him. It's a total disaster. His attitude screams, "I don't care," and the courtroom isn't the place for that. Real talk, never go into a courtroom alone when your future's on the line. This isn't a flex, it's a mistake. With that said, let's dive into today's footage and watch how this Emio vs. Judge Simpson showdown plays out. There's a lot to unpack.
And
Thank you.
so I will not ask you to acknowledge. I will presume that you do indeed understand everything that I've said. Now, having said that, what are we doing with this case?
I'd like to move for evidentiary hearing or a
You wish to have a preliminary examination?
preliminary examination. Yes, sir.
Would the people have their witnesses available the second?
We can try, Your Honor, but before moving toward that, would the court be willing to make its inquiries about discovery? I am aware of the defendant having filed a writ of mandamus with the Court of Appeals for the state of Michigan.
Yes.
That was subsequently dismissed without prejudice by the Court of Appeals.
Correct.
Contained within that, though, there are allegations that my office has violated its Brady obligations and has not provided sufficient discovery. So I'm not sure if we're ready to move forward to preliminary exam. The defendant is saying that he doesn't have all of the discovery. That is the concern. The record I feel compelled to make at this time, though, is that the people have provided, I do believe, complete discovery to the defendant, and I believe that some of the representations that were made in this writ of mandamus that has been dismissed include appear to allege that things that have already been denied by this court should be produced. Furthermore, the defendant filed a motion with no notice of hearing attached to it. So there's an outstanding motion in this case as well, no hearing date scheduled. So I'm hoping that we can sort of reconcile both of those things as whether or not discovery is complete, the defendant's prepared to move forward, and if he ever has filed a notice of hearing to go along with the motion that I received in this case on 11/22.
Mr. Magoo, your response.
My response is that I thought this was the hearing that we were setting for the motion. So if I have to set a motion for a notice of hearing for that motion, I will do that today, Your Honor, promptly.
What about discovery?
I'm ready to move forward on my what I meant by my discovery comment was that there's still no exculpatory evidence as far as that I did anything wrong, as far as anything that they've submitted. So it was improper for the wording, Your Honor, I apologize, but my ultimate goal is have the prosecution present their evidence against me.
I'm going to indicate discovery is complete because I don't know what you're saying. Because what you just said regarding discovery didn't make any sense. As it regards the motion, we will hear the motion or the motion will be heard on date of exam.
Thank you, Your Honor.
Deal with it at that point in time. So the people would have their witnesses available on the second.
We can try for the second, Your Honor.
Preliminary examination in person, January 2nd, 2025, 12.
Yeah.
12 noon, that is before me.
Thank you, Your Honor.
And continue.
This case is a perfect reminder of why having legal representation in court isn't just smart, it's necessary. We're not talking about a minor traffic violation here. This guy is facing serious charges, allegedly assaulting a police officer, and the consequences have already hit hard. He lost custody of his child. That alone tells you the court sees this as a serious, high-risk situation, and yet he walks in without a lawyer, acts smug, chews gum in front of the judge, and behaves like the courtroom rules don't apply to him. It's not confidence, it's delusion. Honestly, this feels less like a defense strategy and more like a slow-motion self-destruction. You see this attitude a lot with sovereign citizens and so-called legal experts who think they can outsmart the system. They speak in riddles, challenge basic authority, and end up doing more damage to themselves than any prosecutor ever could. The reality is simple. Courts don't revoke parental rights without serious cause. His behavior inside and outside the courtroom shows a deep lack of emotional maturity and responsibility, and frankly, it raises questions about whether he was ever fit to parent in the first place. So here's the takeaway: if you're facing serious charges, don't try to be a hero, get a lawyer. Judges don't care about your buzzwords or how confident you sound. They care about facts, evidence, and respect for the process. That's it for this breakdown. I'll be covering the next chapter of this case when the hearing picks back up in January. It's already looking like it's going to be just as wild. If you found this helpful, make sure to like and subscribe. Thanks for watching, and as always, take care and stay informed.